the First Nations. Exactly. So the government essentially stole the land. That's what even the Canadian courts are saying, that the government has to settle the Indian land claims. And the reason is they're essentially saying the government stole the land in the first place. And so really, if you think about it, and this is why I'd like to get some de jure chiefs to sell me some BLM land, and I'd be willing to take it into court because I think I'd win.
So technically, from if I'm hearing you correctly, a de jure government like the Republic of Texas, if they've got all their ducks in a row with a land commissioner and this, that, and the other, then the Republic of Texas can issue land patents.
That's something worth interesting. The question was whether the Republic of Texas could issue land patents, especially on people that are having their house foreclosed on and stuff like that. And that's something that possible. I guess I hadn't really considered that. They could certainly tie it up, you know. But you know, the key is that you know, you need to put the mechanisms in place and do it a few times and see what happens. You know, it's like boiling a frog. You ever boiled a frog?
Right. Please don't give me that analogy again.
Well, it's okay.
De facto politicians have given it a bad name.
Yeah. Well, if you throw the frog in a pot of boiling water, he's going to jump out. But if you put it in there and turn it up, then what I'm saying is that the Republic of Texas should issue a land patent on somebody's land and see what happens. And especially some land that nobody cares about. Right. You see what I'm saying? And then what they do is they gradually turn up the heat. Maybe they issue a land patent on some land that some people care about, and then they issue a land patent, huh?
Like the Capitol building?
Well, that would be the last one. Yeah, that's what I wanted to do in Canada, is to have them issue me a land patent on the Parliament buildings after we do it in some other areas that are not as important. You know what I mean? Right. And then I'd send them a bill for rent, you know?
There you go.
Anyways, food for thought. As we have noted in connection with a patent by the United States, the patent's effect is the same as though the United States had executed a quitclaim deed. Again, you know, it's because it's a colorable title. You know, the highest and best title is a land patent, but really the highest and best title is a First Nations patent. Think about it. That's really powerful. A patent operates as a deed of the government. As a deed, its operation is that of a quitclaim. It passes only the title the government has on the date of the patent. A patent of the United States as a deed, its operation is that of a quitclaim, or rather of a conveyance of such interest as the United States possessed in the land. A land patent is the highest and best title, but at the same time it's a quitclaim deed. If a land patent is a colorable title, then what would be true allodial title? There is nothing here requiring a deed to establish a colorable title, and under former decisions of the court, colorable title may exist without a deed. And that's true. Squatters' rights. Think about it. If you're on the land for 7 years, it's yours. That's why when you homestead, you know, you go and sit on the land for 7 years. I mean, they don't have any choice but to let you deed it over to you, because you basically homesteaded on the land for 7 years. That's the whole idea. Courts have ruled that the government has to settle the land claims of the original people. They're essentially saying the government stole their land. This is actually a Canadian land patent. You can see it's in a box. That tells me they don't have any authority. And if you read it, you know, the fine print at the bottom, they're talking about reserving, you know, all sorts of stuff. And where the U.S. patent, if you read those U.S. patents, they don't reserve anything. And I've got a Texas one. It's in my briefcase. I've got a Texas one, and you can actually, all you have to do is call up the Texas Land Commissioner. They have a website. There's an 800 number. Call up the Texas Lands Commissioner. Give them your survey number for your land, okay? And if it's not on your tax deed, you can call up the planning department for your city or county where you get your tax bill from, and they'll give you the survey number for your land, okay? And then all you have to do is call them up, have a credit card ready, tell them you want to talk to the historical department, and I think they charge like $5 to send you a certified copy of the original land patent on your property. And I'll show you one that I did where I brought forward the land patent on some land out in West Texas. And I'm in a little bit of a battle with them over it because they sent me a bill for property taxes, but I think it'll be a slam dunk. Anyways, this is a U.S. land patent. This is one of those railroad land patents. This is actually the one that they pass around. Anyways, it says here, and granted by these presidents does given grant unto said Santa Fe Pacific Railroad Company to its heirs and assigns, or no, to its successors and assigns, the tracts of land listed as aforesaid and described to the foregoing, to have and sold said tracts with the appurtenances thereof unto them successor as aforesaid, and its successors and assigns forever. It doesn't have any restrictions. There's nothing. It's total and complete ownership of that land. But you know what they do is, and I think they did the same thing. Like if you go back to this one, okay, you'll see that it's the Calgary and Edmonton Land Company Limited, right? I'll bet you that's a Crown Corporation. And I'll bet you this is exactly what they're doing here, because what happens is the railroad company then sells the land. Well, so how do they sell the land? They sell it with a colorable title, right? So they have absolute title, but when they sell it, it's not absolute title anymore, unless the people are smart enough to know that they can bring forward all the rights and privileges of the land patent. You see what I'm saying? Otherwise, they have a colorable title, which is really not a title. And here's the signature part. President of the United States having caused these letters patent. Now you got to understand, letters patent is just a letter from the government under official seal. That's it, nothing more. I can show you letters patents all day long. Anyways, a land patent is just another type of letters patent. Anyways, have caused the letters patent and the seal of the General Land Office affixed hereto, given under my hand, City of Washington, the 2nd day of December in the year 1915, and in the 140th year of independence. And that's it. And there's no reservations at all on that. And recent land patents, if you know up at the, you saw the Crown patent that's in a box, that tells me they don't have any authority. They know they don't have any authority. Land granted to John Smith, his heirs and or assigns forever. All patents that I've seen always reserve something, all Crown ones. They reserve mineral rights, trees, water rights, something. I'll show you that Texas land patent. I'll go out and get it next time out of my car, out of my truck. But in the Texas land patent, it reserves mineral rights. But that's it, nothing else. Right. The land patents say nothing about property taxes, say nothing about easements, say nothing about eminent domain, say nothing about zoning rules and regulations. Okay? So if you bring forward the land patent, you still have real close to absolute title, even if it does reserve mineral rights. Sometimes they reserve mineral rights. Other than mineral rights, there are no reservations in the U.S. And if you look at that one from Arizona, I think they reserved, I'd have to look at it. I think it might have said something about access for canals, irrigation stuff, you know, I'm not sure. Anyways, a usufruct, okay? A usufruct is a noun under Roman or civil law, the right of enjoyment of all the advantages derivable from the use of something that belongs to another, as far as is compatible with the substance of thing not being destroyed or injured. A usufruct is a type of a trust, okay? And that's what's happening is, that's why they spell your name in all block capital letters, because it's not you, it's the trust. And what they're doing is they're charging you a fee to manage your trust. That's exactly what's going on.
I think sometimes in Texas this is called a life estate.
Well, that life estate is another type of estate.
Yeah.
Yeah, that's any law dictionary has life estates in it. That's just another type of estate. And so a usufruct is not a type of a life estate. A life estate is something that you get to use it for the rest of your life. And so that's not a usufruct. A usufruct, you get to use it and you can pass it on to your kids. And so it's not for life. It's, you know, and you pass it on for your family, and as long as everybody's paying the tribute. But again, if you want to have absolute ownership, you bring forward all the rights and privileges of the land patent and pay for it with coin, and make sure that that usufruct isn't set up. Then you'll have absolute ownership of the land. Federal Reserve notes. This says Bank of Canada notes. Federal Reserve notes are promissory notes. The forced loans of 1862 and 1863 in the form of legal tender notes were vital forces in the struggle for national supremacy. They formed a part of the public debt of the United States, the validity of which is solemnly established by the 14th Amendment. Okay? So then Federal Reserve notes are promissory notes, aren't they? They're commercial paper. When you pay for land with a banknote, it is not paid for, therefore a trust is created. That's why the government has eminent domain. The government stole the land. By paying for the land with commercial paper, you gave it back. Or the government sold the land, and then by paying for the land with commercial paper, you gave it back to them. Have you ever seen a road that goes along in a straight line until it comes to somebody's land and then goes around the land and then keeps on going straight? Well, that's because that guy had eminent domain. They didn't have eminent domain on that guy's land because he didn't have colorable title. There's people in Arizona that I know that have passed their land on in the family from generation to generation. They've held it in their land in the family for generations, and they do not pay property taxes. There's no record of it anywhere. And it's their land, and they keep it, and they pass it on from grandmother to son, and just like that. And so there's Spanish land grants in Arizona, that huge tracts of land that were granted by the Spanish government back in what, the 1600s or the 1700s to these Spanish families before Spain was even separate, before when Arizona was part of Mexico. And before Mexico was separated from Spain, you know, they granted these huge tracts of land. Those Spanish land grants are still there. And if you have absolute ownership of your land, you just pass it on in your family, yes. Well, it's as long as it's not transferred, then it is free by definition. You see what I'm saying? I haven't seen the Spanish land grants, but I've seen the maps that have it all marked out. And yes.
I have a friend whose family is part of a Spanish land grant up around Las Vegas, New Mexico. And the state of New Mexico took a bunch of their land away from them a long time ago, and they just won a lawsuit getting that land back.
Right on. Right on. How did they, obviously they didn't have a shred of authority because the courts ruled against them, but I just can't believe that they even tried.
Yeah. They got their land back, I know that.
Yeah, they was talking about Spanish land grants in New Mexico and how the state of New Mexico stole the land, and they just, there was a lawsuit, and they lost the lawsuit. Anyways, okay, so, okay, we've already talked about this. Spanish land grants in Arizona. Evidence of your usufruct, okay? They call it real estate. You pay a yearly rent. They take it away from you. They can take it away from you with eminent domain, and if they can take it away from you, you don't own it. Your land has easements, utilities, roads, etc. Your land is subject to zoning rules and regulations. That's all evidence that you don't really own it. If you pay for land with a promissory note, it creates a trust. The way you defeat the trust is you have to pay for the land with gold or silver coin, and you have to say it in the deed because they can presume that you're using commercial paper. You know, most of these deeds say upon receipt of $10, and it's an S with one vertical bar, as, you know, upon receipt of $10 and other good and valuable consideration. Well, you know, obviously they can presume it's commercial paper. How can